In this video segment, we're going to talk about recruitment, tenure, dismissal, and due process regarding employment and employee issues for school administrators. One of the most important things for new administrators to learn about these type of employment issues is that a good human resource person at the district level and well-trained administrative staff from the central office to the school level is absolutely important. And doing investigation of misconduct is a skill that all administrators should learn. Doing the proper type of investigation with good documentation, understanding the role that supervision plays, but also the role that due process plays, both oral and written notice and explanation of the charge and their evidence and their right to explain themselves and their side of the matter. Reporting misconduct to the Education Professional Standards Board and other applicable agencies that might be relevant in circumstances of the misconduct. And then, of course, dealing with suspension with pay pending the outcome. Most of the time, that's the protocol that's followed. And then ultimately dealing with resignation, non-disclosure, and defamation, the agreements, and how things are handled when you get into those kind of situations. And, you know, as you deal with contracts, contract law, we start into the idea of tenure. In Kentucky, there are contract levels we called at-will employees, which are employees that are completely employed at your will as the employer, and they are typically classified. And so the cause for there's really no reason has to be given to end the contract. So the cause and is really not relevant in that respect. And then, of course, on the certified side, you have probationary, which is a Kentucky limited. In Kentucky, it's called a limited contract. That's a yearly contract that occurs all the years up until tenure. And then there is a continuing contract, which is a tenured contract, the first day of the fifth year. That is the way you measure the time. Once you go to work on the first day of your fifth year, then you are a continuing employee, which means that the burden of proof shifts. The district must now show cause to remove you from the role. And so that's really an important distinction. There's one other classification of employee that occurs in Kentucky law, and that's term employments. And this usually refers to the superintendent because it's a specified amount of time, usually 4-year terms of their contract of employment. So, you know, districts, recruitment and retention and maintaining the best and most diverse qualified teachers based on the school district's capacity to provide adequate compensation is a really critical thing, especially critical now in the ages of shortages. The school districts recruiting and maintaining competent teachers should project a professional image and also support the district's mission. And a really important component of the recruitment and selection process is making sure that you do things legally, well-organized, legally defensible interview process, as well as creating an overall impression and assuring that there's no unfair treatment. And so those are all aspects of the hiring piece. Of course, hiring discrimination is, these cases emerge. We talked about in the last segment a bit. They emerge even under the best circumstances. Well-developed and focused employment policies and practices always don't insulate, so there are always going to be issues. But it's really important to make sure, you know, that good records are kept and all the proper procedures are followed with regard to making sure that there's no hiring discrimination. There's always an ongoing debate about tenure, those continuing contracts, and the need for tenure. The traditional view is that tenure provides a measure of security and insulates teachers from arbitrary, capricious, and political actions, which I think has become more and more important and understood in recent years since the pandemic. The opposing view suggests that tenure protects ineffective teachers and perpetuates a mediocrity in the classroom, and tenure should not preclude dismissal where there is documented evidence of ineffectiveness. The school officials have a leading responsibility to ensure that only competent teachers teach in classrooms. And of course, these disputes arise regarding interpretation of requirements for attaining tenure, and there's a lot of case law where this is brought to the forefront. But generally speaking, the burden shifting to the school district to show cause is become a very high bar, especially in the age of having professional associations and union contracts that defend any kind of behavior from teachers that are in tenure roles. So documentation, as I mentioned earlier, is really important, and the primary purpose of this system of evaluation and documentation is to improve performance, but ideally teachers should set performance goals and work with their supervisor, all the things that we've talked about through the instructional side of your work in this program. But an important element regarding teacher performance is making sure from a legal standpoint you do the documentation. The instructional leader should provide timely, constructive feedback, multiple data points and sources to assist the teacher in their efforts. And teacher strengths should be emphasized. Areas of improvement should be highlighted. The instructional leader should also offer necessary assistance and support that will enable the teacher to meet their goals. When you consistently do that and you consistently document that you've done everything you can to continuously support those people, that documentation leaves a paper trail that allows you to deal with challenges that come up. And so that focus on documentation really centers on the connection between teacher performance and improved student performance. And if documentation is going to be used for any purpose other than personal growth, then you must inform the teacher and provide them with that information. Documenting misconduct it goes even a whole step further, because all teachers should have their performance documented, but documenting misconduct involves many forms of behavior, from harm to students to falsifying credentials to cheating on professional exams. It runs the gambit. In all cases, teacher misconduct must be properly documented to include the alleged offense, the approximate time which the act occurs, witnesses, if any, that verify that alleged misconduct. Documentation is also important in assisting the teacher in understanding that certain types of behavior are not acceptable, and more importantly, to levy dismissal proceedings against a teacher depending on the severity of the act. Substantial documentation is absolutely pivotal to dismissal proceedings. And there are several decisions where inappropriate or inefficient and insufficient documentation has been the pivotal point of the case. Documentation of misconduct really is what facilitates the understanding of their unacceptable behavior and does lead to their dismissal. Non-renewal is where you take a probationary teacher that hasn't reached tenure, and that person may be non-renewed at the end of the contract year, since his or her property interest ends when the contractual obligations have been met by the teacher and the school board. In this instance, absent of any employment, if a non-tenured teacher has made a claim that non-renewal was motivated by any areas listed that we talked about with discrimination, then the burden of proof rests with the teacher. That's the difference. Tenured employees are removed. The burden of proof is on the district. Non-renewed, non-tenured teachers, the burden of proof is on them to show any type of discrimination or inappropriateness. Dismissal for cause is a serious matter, and that is one that is not to be taken lightly. And it's a very expensive proposition from a legal standpoint. State statutes prescribe permissible grounds on dismissal based on several of those. In Kentucky, the misconduct grounds for dismissal are insubordination, neglect of duty, incompetence, immoral conduct, and conduct unbecoming a teacher. Those are the grounds. Incompetency is perhaps one of the most frequently used grounds for dismissal. It's a fairly broad term, and it may cover areas like inefficiency, a lack of skill, inadequate knowledge of the subject matter, inability or unwillingness to teach the curricula, failure to work effectively with colleagues, parents, poor classroom management, failure to discipline, attitudinal deficiencies. It's not surprising that incompetency is frequently used based on the scope of behaviors linked to it. And there are some cases that show that, but it's also sometimes one of the most difficult ones to prove because there are so many judgment and subjective elements of that. Criminal activity is another reason used against public school teachers. It will generally result in dismissal based on unfitness, immorality, and unprofessional conduct. Depending on the nature, severity of the specific criminal act, revocation of the teaching certificate also can occur. And it's generally known that dismissal for unfitness may not necessarily involve criminal conviction. The school district may address teachers' behavior from a standpoint of fitness to teach, irrespective of whether it's criminal or even a criminal conviction, simply because the standard of proof is higher to sustain a conviction than it is to dismiss a teacher. And so there are also some of this misconduct that is more common is sexual advances towards students. Courts have left little doubt that they will deal judiciously with matters involving improper conduct towards students. That is a very easy dismissal for conduct unbecoming and for immoral conduct. This really does not exemplify professional activity of those who teach and maintaining the high standards of professionalism, especially towards students. Teacher on student sexual harassment represents another form of discrimination prohibited by Title IX. The courts have been consistent also in ruling against teachers for sexual misconduct involving students, and they've held school officials liable in many of these cases where they were aware of the harassing conduct and failed to take the appropriate steps to address the problem. So since students are in a functional custody of school personnel, they have the right to receive protection from harassing conduct by teachers. So it's not only the teacher that's on the hook in many of the harassment issues, it's also the administrative team. All students must be provided equal access to education, and deliberate indifference to harassment of students by teachers is unacceptable and will not receive support in the courts. Revoking a teaching certificate is normally associated with a felony conviction and series of misdemeanor convictions. For example, if you have a plethora of drunk driving charges, you may see that, although it's less common than it used to be. The courts have, or the fundamental issue that arises regarding revoking a teaching certificate involves the teacher conduct, suggesting an unfitness to be in the profession. The Erb case that we talked about, the Iowa Supreme Court with the teacher that was having an affair with another teacher, they emphasize that the board's power to revoke teaching certificates, the state board, is neither punitive nor intended to permit the exercise of personal judgment by board members. The court indicated that punishment is left to criminal law. However, fitness to teach can be determined by the board, since teachers occupy sensitive positions where they exert influence over students, and they are expected to set positive examples in what they do. So a teacher's out-of-school conduct may affect their classroom fitness, but again, the Erb case kind of drew the line at some of the adultery issues as being in and of themselves unfitness for teaching. Abolition of positions is another piece, and this is a bona fide financial exigency that is justifiable as a way to dismiss personnel, including tenured teachers, if necessary. And so these bona fide financial challenges that occur when the district faces a reduction in budget, it creates a need to reduce the workforce. And of course, it may stem from reduced revenue or reduction in student enrollment. The courts generally support districts that demonstrate the need to reduce their teaching force when there is a documented level of evidence that legitimate the financial concerns. The courts tend to view reduction in force, RIF, that includes seniority, as one of the major criteria in reaching termination decisions. And of course, the courts have illustrated that point. So if you're going to do an RIF, they call them RIFs, reduction in force, to eliminate a really poor old teacher, you have to make sure that that teacher is the only one in that department being eliminated. So because you have to use seniority. The FLSA, the Fair Labor Standards Act, requires that employees in the United States be paid a minimum wage for hourly work. This applies a lot to classified employees, people like bus drivers and cafeteria workers who are among the lowest paid. It further requires overtime at pay and 1.5 at regular rate hours worked beyond 40 hours a week. Executives, administrative professionals are not covered by FSLA. They are typically considered to be salary or exempt employees. School leaders must be cognizant of the components of FLSA in relation to non-exempt employees so that they ensure that all are in full compliance of the statute. Non-exempt employees in public schools, as I said, are your clerical, food service, custodial, and security type of personnel a lot of times. So collective bargaining is one of the last issues that I'll mention, and that relates really to districts that have agreements with unions. There are some districts in Kentucky, like the Jefferson County Public Schools and the Boone County Schools in Northern Kentucky, that have collective bargaining. This is growing in popularity and appeal, and it does evoke some controversy because they view this as a mechanism to achieve a greater role from the in the management of schools from the standpoint of the union. And so as things change in public schools, with benefits, with pay, with some of the challenges in the profession, you're seeing more and more of these conflicts with respect to collective bargaining. And so it's an element that you'll see, I think, emerging as a theme in school law as you move into the administrative ranks.